All right, let's go. In introduction. Chief Judge Glanvilles ruling that statements made by young YSL member Damikian Garlington to fellow YSL member Kenneth Copeland are admissible co-conspirator statements under OCGA 24, blah, 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 is proper and need not be reconsidered. On September 30th, 2022, defendant Stilwell filed a motion in limine requesting hearing and objecting to the admission of these co-conspirator statements as inadmissible hearsay. Ultimately, Chief Judge Glanville held the hearing and denied defendant Stilwell's motion. Footnote. State agrees with defendant Stilwell that the record does not reveal any written order encapsulating the court's oral ruling preliminary admitting the statement subject to proper foundation at trial. This is one of these oral orals where he actually never wrote it down. It might be, there's no written order, just an oral order. Only after recusal on July 23rd did defendant Stilwell file this motion to reconsider. There is no legally salient intervening change in statute or jurisprudence warranting reconsideration. Therefore, this court should deny this thinly veiled attempt at the de facto judge shopping, because the court's prior ruling was in accordance with this OCGA. However, if the court is inclined to consider defendant Stilwell's motion, the motion should be denied. I'm not entirely sure. I mean, because they had the motion really early on, but there wasn't an actual written order to deny or anything throughout that almost a year and a half since then. So I'm not sure. If my gut tells me that the state will win this one so far, because it's a bit too late. But then again, the Copeland is on the stand now, so it is kind of timely anyway. I'm not sure. Factual background. The defendants are all charged under count 1 with violation of the RICO Act for their participation in the conspiracy of the criminal enterprise of the YSL criminal street gang, which I believe the state they're not even close to proving that they are. That is why the prosecution is keep talking about this hybrid gang between a normal street gang and a criminal street gang, which is stupid. It's either or according to law. You're either a normal street gang, which is not illegal, or a criminal street gang, and that is up to the court to decide. The hybrid thing, garbage. As alleged in the indictment, the objectives of the objectives of the YSL include, but are not limited to, preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, blah, 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 blah. This is count 2, ending, as well as overt act 16 to 20 of count 1 pertain to the January 10th, 2015 gang-related drive-by shooting of Mr. Donovan Thomas Jr. Go back and watch my stream. When we discovered together that the white car, or the light-colored car, the prosecution alleges contained, whoever it was. Looking at the grill, it's not the same car. It's not the same car at the gas station that is seen on the surveillance camera driving by. It is not the same car. In my opinion, I have to add that. If you disagree, please say it, but I don't mind you telling. I will never, ever, if you have constructive criticism of anything I say or do here, speak out. I don't mind. I welcome it, because I do not learn anything if I only have yay-sayers. Now, I love my yay-sayers, but I also want the nay-sayers. Okay? On June 10th, Mr. Copeland was interviewed at the Atlanta Police Department, headquarters by Detective Thorpe, Detective Dennis, and Gang Detective Gaither. The Gaither is, in my opinion, probably the absolute least competent cop I have ever witnessed in any trial. Now, you have people who lie, who cheat, who steal, and do all of that. Miss Gauthier is simply a dumb person who managed to get a job as a cop, got department pinball machine thingy. She ended up in the gang unit. That is not a clever person and completely incompetent. And I will stay. She is. I've said this before, but for you who are new here, she left the force after 19 years, not 20, as for getting full pension. Isn't that strange? Why would you leave after almost 19 years? Then she got a job as an investigator at Cook County, the neighboring county, for the district attorney's office. She worked there for a few months, and then she quit. For you know, I do labor law. If somebody is at a position for a few months and then quits because it wasn't for her, that is her employer telling her, either quit or you're fired. That is my opinion, what happened. So that's, who else was there? During this interview, Mr. Copeland stated that YSL member Garlington informed him that the defendant Stilwell and other co-defendant associates Cobb, McCullen, and Kendrick were responsible. Copeland, that's one step removed, said that Garlington, that's two steps. Garlington informed him that these people, this is 3 times removed hearsay, that somehow Judge Glanvilles found a reason to admit. Third-hand information is what Judge Glanvilles thought was proper as evidence in this trial. Third-hand hearsay. I'm having a hard time with second-hand or even first-hand hearsay once in a while. But third-hand, that's the whispering game. Seriously. Also, Copeland discusses other activity that Mr. Garlington shared with him. Again, a lot of hearsay here. For example, discussions about the April shooting of Dwayne Carter's tour bus. That's Lil Wayne, by the way. Mr. Copeland stated on January 10th, sometime shortly after the ending, he met Garlington at a McDonald's parking lot located at Cleveland Avenue. Mr. Copeland saw multiple YSLs arrive at the McDonald's, to include defendants Garlington, McMullen, Williams, Stilwell, Kendricks, and Treadwell. Garlington entered Copeland's car and immediately told him that they just killed Nutt. Mr. Copeland, that blah, 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 blah. Yeah, we all know that. We heard that. Yeah. So this is just a reiteration of the some are in the interviews, in the police interviews, some are in jailhouse calls, and some. Yeah, in my opinion, when you look at the grill of the car at the gas station, which they have clear photo of, and then you watch the drive-by of that light-colored car, it's not the same grill, which means it can't be the same car. Blah, blah, blah. Argument and citation of authority. Statements made in furtherance of the conspiracy are not hearsay. This is here's the thing with the Georgia RICO. What is written there? Statements made in furtherance of the conspiracy are not hearsay. Is probably how the Georgia RICO Act is written. Probably. And it's stupid, and it's unconstitutional, in my opinion. It should never be allowed. But welcome to Georgia. Defendant Stilwell's argument ignores numerous facts and controlling legal principles. More significantly, defendant Stilwell fails to recognize that this is a gang and criminal enterprise prosecution. Here's my objection to this part. Just because the charge says it's gang and criminal enterprise, and therefore hearsay should be allowed, or not, statements are not hearsay, I don't care. Hearsay rules are hearsay rule no matter the charge, except in Georgia and a few other states. It's stupid. As such, the underlying conspiracy in question pertains not only to the ending of Mr. Thomas, but more broadly to the activities of the YSL gang. Therefore, the conspiracy in question continues today. YSL continues to exist and operate as a criminal street gang. Then why, Miss Love, Miss Willis, Hilton, and everybody else, if they are a continuous criminal street gang, why aren't their music label on a co-conspirator? They bought the YSL music brand with all the everything in it. The YSL music recording business is now under other management. Cash Money Cash. I think they skipped the part where they have to prove RICO first. Yeah, but that's the odd part. It seems like just because they charge under the RICO, there are different sets of rules. And I don't understand how they have statutes for it, but Georgia has statutes for it. Hearsay, Nick, I heard you are a billionaire. Maybe in Kenyan dollars, or I don't know. No, I'm barely a thousandaire. Everything I get from this channel goes back into the channel. And even the trip to the United States, which you guys have so generously contributed to, I still have put in my own money into it. But thank you so much for watching this, giving me some ad revenue, the occasional super chat, and gifted memberships and being members. Thank you so much. I cannot thank you enough for that. You make this, what I do here, possible. And my trip to the United States, where I traveled to the different places where I have covered cases. And by the way, that's a week and a half from now. I fly out on August 7th from Sweden via Denmark, Holland, and then over to the United States. I will land at about 2 p.m. in Houston. I think it's the George Bush Airport. I don't know what it's called. But again, thank you all so much. So in Georgia RICO, any loose affiliation or accusation towards the case is considered fact. Yeah. Then they leave it all up to the jury to decide if what they put forward is enough to prove. Because according to Judge Glanvilles, when he made this ruling, the prosecution only needs to show a preponderance of the evidence in order to get these things in. Like, it's 50-50, but with a feather. And for me, that is stupid. Yeah, remember, hit the thumbs up while you are here. Help me beat the YouTube algorithm to get me out to more people to see me. And Garlington's statements, better described as party admissions to Mr. Copeland, were in furtherance of that conspiracy. OCGA 24, blah, 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 blah. Admissions shall not be excluded by the hearsay rule. An admission is not only defined as a party's own statement, but it's also defined as a statement made by a fellow co-conspirator during the course of a conspiracy. So, to make that as short as possible, if the prosecution says you are affiliated with a gang, that's enough for us to use anything you ever said to somebody that we can get somebody to testify about. Regardless how much hearsay, regardless how much, they don't even have to prove it's a correct statement, only that the statement should be admissible. We don't know if that statement actually occurred. All we have is Copeland saying it occurred. So we actually don't know if that statement by Garlington actually happened. We have no idea. But the state says that Copeland said it, and therefore it's admissible. That's the vagueness of the Georgia RICO Act. OCGA mandates that hearsay proscriptions do not apply to, quote, a statement by a co-conspirator of a party during the course and in furtherance of the conspiracy, including a statement made during the concealment phase of that conspiracy. To admit evidence under the Rule 801, the Georgia Supreme Court has held. The state is required to show by a preponderance of the evidence that a conspiracy existed. The conspiracy included the declarant and the defendant against whom the statement is offered, and the statement was made during the course and in furtherance of the conspiracy. It is like this because the prosecution says it is like this. It's a circular argument approved by the Georgia Supreme Court. Criminal conspiracy. The YSL criminal street gang is the criminal conspiracy in this case, as alleged in count 1, and as the evidence at trial has revealed. No, it hasn't. According to Judge Glanvilles, it's in preponderance of the evidence. Okay, so he found it 50-50 with a feather, which is stupid. A criminal street, blah, blah, blah. I don't have time. This is... Does she have any... Yeah, let's go. Statements made in furtherance. By the way, just so you know, for you who don't know, you are all part of Mr. Jingle's Viking Thug Gang. Both the 11th Circuit and Georgia courts apply a, quote, liberal standard in determining whether a statement is in furtherance of a conspiracy, end quote. liberal standard means, in plain speak, we want to help the prosecution prove a case as much as possible, no matter what other rules we break. That is the meaning of that. To be admissible under this code section, a co-conspirator admission, quote, need not be necessary to complete the conspiracy, but must only further the interest of the conspiracy in some way. I mean, the vagueness in the language here is infuriating. And this is not because of love of Hilton or even Judge Glanvilles. It is because the lawmakers in Georgia wants it to be this way. Yar is here. Statements between co-conspirators which provide reassurance, serve to maintain trust and cohesiveness among them, or inform each other of the current status of the conspiracy, further the ends of the conspiracy. Here's my issue. This statement is only spoken by Woody. We do not know if Garland actually said it, unless he's in a recording, which we don't know yet. Even boasting or bragging is in furtherance of a conspiracy if the statements, quote, are directed at obtaining the confidence or allaying the suspicious of co-conspirators. Boasting or bragging or lying, maybe. A statement can also be in furtherance of a conspiracy when it is, quote, necessary to keep a co-conspirator abreast of the conspiracy's current status. Furthermore, narratives of past events, however, are admissible under Rule 801 if they serve some present purpose in the conspiracy. I mean, the vagueness in this language should not be constitutional. I mean, for over here at least, we have a rule that in order for a law to pass the legislators, you should be able to read it to a 15-year-old, and that 15-year-old understands it after the first reading. Now, our politicians, they don't follow it, but we try to follow it and hold the politicians accountable when they go haywire. In Georgia, this is on the lawmakers, completely on the lawmakers. The lawmakers could make this disappear after the election. But I don't believe any of the parties in Georgia are interested in good laws in this period. Statements are admissible where the state can meet the requirements of Rule 801. Any co-conspirator statements made in furtherance of the YSL are admissible as non-hearsay statements. Notably, the state need not prove the existence of this conspiracy prior to the admission of the statements at trial. Chief Judge Glanvilles has stated, and the state has introduced evidence at trial that has proven to a preponderance that YSL is and was on January 10th, 2015, a criminal street gang. It is this stupid. Cash Money Cash says, so for example, by having an improper ex parte, Judge Glanvilles is a co-conspirator to the prosecution's dealings because it, quote, furthered the interest of the conspiracy, quote, to derail the defense. Yeah. Another example is Fonnie Willis conspired with Nathan Wade to embezzle money from Georgia taxpayers. 2 or more people is enough to have a criminal conspiracy or a criminal enterprise in the state of Georgia. Just saying. Application and analysis. Currently, the state has already provided evidence and testimony to prove by a preponderance of the evidence that YSL is a criminal street gang. And both Kenneth Copeland and Demikian Garlington were members of said conspiracy on January 10th, 2015. Here is my issue with this. in my opinion, the only people who can decide if there is a preponderance of the evidence is a jury. Sadly, there seems to be a grand jury in place here. And most of you already know this, but you can indict a ham sandwich in a grand jury. Rarely does a grand jury say, no, we're not doing this. The YSL gang is an ongoing enterprise and conspiracy, and now they keep repeating. Prosecutor loves repeating herself over and over again because that makes her motions longer and seem more important, unless somebody like me shows up. For you who don't know, I spent 3 years in the European Parliament as a documents analyst. I literally read tens and thousands of garbage papers. This is a garbage motion. I don't think Adrian Love has the mental capacity to write a good motion. I honestly don't think. The only reason here why this has bearing is because the laws and statutes she relies on are equally bad as her. Do I want to... Yeah, this is just Inglewood family bloods, blah, blah, blah. Alternatively, the evidence is also admissible as a declaration against interest. Mr. Garlington's statements to Mr. Copeland is also admissible as a declaration against interest pursuant to these rules. The code permits the admission of a hearsay statement, which a reasonable person in the declarant's position would have made only if the person believed it to be true because, when made, it was so contrary to the declarant's proprietary or pecuniary interest or had so great a tendency to invalidate a claim by the declarant against another or to expose the declarant to civil or criminal liability, ... and supported by corroborating circumstances that clearly indicate the trustworthiness of the statement if it is offered in a criminal case as a statement that tends to expose the declarant to criminal liability. This is word vomit. Apparently, this is some judge decided, I want to write it this way. I don't know who it is, but whoever it is, Jesus Christ, don't stop being a judge. This is a very, very, very wordy way to say, if a reasonable person believes it, then it comes in. What's a reasonable person? Well, I have no idea. Many people with high intelligence are not reasonable at all. Many people with low intelligence are highly reasonable, and every variation in between. That reasonable person standard, in my opinion, should only apply when it comes to free speech decisions. What would a reasonable person deem offensive? And there are so many now that I'm not even sure of that anymore, because there are lots of easily offended people out there. Lots of them. Or there are very few, but extremely loud. I don't know. To be admissible under Rule 804, a statement must satisfy 3 requirements. The declarant must be unavailable. That would be Mr. Garlington. Okay, why is Mr. Garlington unavailable? Garlington, YSL. These Why isn't he available? Let's see here. Garlington. Are these people who are severed? Yeah, it seems like Mr. Garlington is severed from this case, but the only reason the Garlington is unavailable is because the prosecution don't want to call him. I don't know. The statement so far tends to subject the declarant to criminal liability that a reasonable person in his position would not have made the statement unless he believed it to be true. And the statement is corroborated by circumstances clearly indicated its trustworthiness. Yeah, it's so vague. I hate vagueness. I want laws and statutes to be clear-cut, as clear as possible. The United States Supreme Court has previously explained the logic behind this rule. Quote, Rule 804 is founded on the common sense notion that reasonable people, even reasonable people who are not especially honest, tend to not make self-inculpatory statements unless they believe them to be true. Further, quote, courts have held that the mere fact that the recipient of the information was a confidant of the declarant does not rule out admissibility of a statement against interest. Is this the United Supreme Court? I think this is taken way out of context. Yeah. Is my blood sugar a little low? I don't think so. I don't think that. Garlington's statement was a declaration against interest. Mr. Garlington's statement to Mr. Copeland admitting his knowledge about the ending, other crimes and its perpetrators. We don't know if he actually said this. Do we? I have yet to hear anything about any recording of Mr. Garlington saying anything of this. All the prosecution have is Copeland, Woody, saying Garlington said it. First, Mr. Garlington is charged in this case with Stilwell. Assuming Garlington does not testify, he is unavailable for purposes of Rule 804. Well, have they tried? Why is this admitted before they know if Garlington testifies or not? As to the second prong of the analysis, Garlington's statement is self-inculpatory. Garlington has significant information about the gang-motivated crime, and Garlington is a member of the same criminal conspiracy as those he named. How do we know he actually named them? And by the way, when we talk about people who are involved, where's Mondo? Fannie Willis, where's Mondo? Why isn't YSL Mondo anywhere seen in this indictment? Well, we already know that. Why? Because Fannie Willis represented Mondo in a case years ago. It is my opinion and my theory that Fannie Willis got every base fact about YSL in order to do the prosecution from Mondo. In my opinion, the only way Fannie Willis could get this amount of information was if Mondo told her as her client. In my opinion, Fannie Willis should be investigated thoroughly for breaching attorney-client privilege. Well, I haven't covered this garbage trial for over 2 years. I've been covering this case for 14 months, 15, something of the sort. Therefore, given the context of Garlington's relationship with Stilwell and the other YSL associates who blah, 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 Garlington had no reason to lie. We don't even know if he said it. We don't actually know if Garlington did the statement. All we have is Copeland saying he said it. Finally, as to the third required prong of the analysis, court has found that self-inculpatory statements are sufficient, corroborated where the evidence presented at trial supports the veracity of the out-of-court statement, and where the declarant makes the statement to someone with whom he shares a close relationship. Mr. Copeland and Garlington are members of YSL with shared affiliations, shared a relationship for a number of years. Mr. Copeland testified that out of all the YSL members, he is the closest to Garlington and Stilwell. These conversations were not to law enforcement, but amongst close members and friends. Are there any recordings of this? Are there anything but Copeland's saying so? Anything? I don't think so. Therefore, this statement is not only admissible as co-conspirator admission, but it is also admissible as a statement against interest. This court should thus deny Stilwell's motion to exclude this statement and hold that this statement, as any other related statements, are admissible upon the state establishing the proper foundation at trial. Mr. Garlington's statements to Mr. Copeland was correctly held to be admissible in this case by Chief Judge Glanvilles and should not be reconsidered. Did I miss anything here? Because I have yet to hear Garlington claiming he said these words. To my knowledge, the only person claiming that Garlington told this to Woody is Woody. Contrary to Stilwell's claims, the Georgia Evidence Code has blah, 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 blah. Adrian Love, again. She, except for one reply by Fannie Willis, they are all written by Love. And you see here, where are Hilton? Where's Hilton? Why hasn't she signed it? Where are the other prosecutors in the prosecution's team? Why is it only Adrian Love here?